Yes. So I want to ask about maybe what, when you marvelously describes the change of attitude and approach from post-World War I to post-World War II, and similar to Tyre, ask what can explain this, and I looked at, looking at your sources, you refer mainly to European scholars in the post-World I era, and mainly continental lawyers, or continental legal scholars and philosophers maybe. And this resonates with what we know about the idea of solidarity that is very continental European and mainly French. So we have this, again, I refer to the book by Emmanuel Journet, What is a Fair International Society, where she elaborates on this French-based idea of international solidarity that begins in the mid-70s. And so with the idea of French solidarity and with you, if post-World War I, can we say that post-World War I was a European moment for international law, and therefore this continental European approach to solidarity, this hope in international institutions, hope in the new League of Nations, and this what facilitates the idea, what drives the idea of international society with the individual human being in the center. And then post-World War II is actually the superpower moment. And then you have the US on the one hand and the USSR on the other hand, and Europe is crushed and Europe is silenced. And there were two very realist forces that say, forget about international community, there is none, and we have to work again to the realist, from the realist perspective.
Okay, so Mira, you can now respond both to Tali and
That's it? Okay. So I'll answer Eyal's first, and then I'll try to cycle back to some of the points that you've made. So can we tell this as a Central European story? Is it limited to that? That's definitely one way to tell it. Why is it that there are so many many Jewish, not only Central European legal scholars expressing a particular kind of legal utopianism? It's not an unfair interpretation. One could say that. But, I mean, the difficulty there, and it's certainly the case that it's more the jurists from the Russian Empire and from Vienna who write the most prolifically about statelessness. That's not an accident. It's those are the people that are, they're affected precisely with this problem. But if you connect the way they conceptualize the problem of statelessness to a much broader critique of sovereignty after World War I and to this sort of the problem of the absolute state being the central problem of the age, and the idea that kind of World War I was a result of this kind of unilateral state, that occurs across the board. The possibility of kind of rethinking legal personality outside of states is not a Central European phenomenon. It's happening in a particular way in the British case, coming out of Gierke. We heard a bit about it in Jean Cohen's paper. Certainly international lawyers with a particular, you could say, idealist bent in the United States are interested in similar things, Philip Jessup. So it becomes difficult to reduce the argument to Central European homeless lawyers in some way. That's the difficulty. And I'm sympathetic to that argument in some way, but then the problem becomes explaining these much broader intellectual developments. And I think what's interesting about the statelessness case isn't just that it's people who have to deal with a problem on the ground. That's certainly true, but that it appears to lawyers as a way to think about it's important to them because it's part of a larger discussion about legal personality that lots of people are talking about. And maybe it's because the problem of refugees and the stateless, as dire as it was in in that post-war moment was not as dire as it was after World War II. I mean, so the numbers do matter in that sense. In terms of kind of the solidarism, I mean, so solidarism is one strand of the intellectual history. It's not the only one, because if you are coming from a French context and reading a lot of Durkheim, then you sound like a solidarist in this kind of international universe. If you're from Vienna, you sound more like Kelsen. I mean, and so you precisely don't sound like a solidarist. But at the same time, there's a convergence on the idea that the state should not be the sort of central font of authority, that there are forms of community outside that sort of individual, that particular political space. I was really interested in your comment about the 70s and 80s, because it seems to me that one part of the development, I mean, I trace it a bit in the paper, I mean, is that statelessness stops being important in political theory. I mean, and it sounds like, and I'm not, maybe you know more about this than I do, it sounds like there is a moment when it starts, there's a convergence between thinking about the state in a kind of legal theoretical way and thinking about the problem of refugees and the stateless, because it seems that those two things come apart after World War II. And I don't think it's coincidental, thinking about institutions, that, at least in my research, I mean, and this is an empirical study. You know, I went to archives, picked it, facts, as however you want to define facts. And the League of Nations was a very realist institution, and I think you're absolutely right that defining problems in international terms was exceptionally useful for a lot of powerful actors. But there's a real split between the kind of free-floating lawyers that I'm looking at and the League in the interwar period. You don't have that same split after World War II. Suddenly, these sort of peripatetic legal figures like Lauterpacht and Paul Weiss and others, I mean, they work for international institutions. They start thinking about problems in a more practical way. So I don't think it's an accident that maybe they were freer to dream. But, cosmopolitan, I agree, is a very awkward term, and I hate using it. And if you have a different term, I'd be happy to take it on board, because they're not really cosmopolitans, and a lot of them don't really have a problem with empire at all, which is why they're willing to kind of take on board some of the institutions of empire to think about the problems within Europe. So.
Yeah, thanks, Mira. I'd like to pick your brain a little bit about certain sentences that you said but didn't elaborate, and it really interests me. First, why did you frame it as 41 to 58? It's kind of an odd framing. 59, actually, we have the Declaration of the Independence of Nations, which is very significant. Maybe it's something to do with that. And then, drawing on that, in 59, more or less, is consensus that the concept of self-determination has moved mainly with a meaning to be territorial rather than ethnic. And yet, prior to that, and perhaps at present time, it has a more ethnic or cultural or national meaning. This is what Benedict Anderson called the perpetual crisis of the hyphen between nation and state. So I'd like to pick your brain about the jurist debates about what does it mean to have self-determination, who holds this, because of course it's directly related to the issue of sovereignty. And perhaps a comment about where it's going from your research, where it's going in terms of what we see now. Like the collapse of the Soviet Union was, I think, a point where the territorial definition of self-determination was at its peak because it's so ethnically mixed, and yet it broke down according to some artificial territories. But of course we see with the Ukraine, etc., that it's not as solid as we thought. So maybe a comment on that.
So on your first question, very perceptive to pick up on that it's really a title that relates to a paper that I didn't really write here. I was thinking about doing something else, so it's not that different from what you see, but those dates, they're not accurate here. That's right. In terms of the self-determination. I mean, so I think what's very weird about my project is that self-determination is a very important concept after World War I. That's what Woodrow Wilson talks about. It's what Lenin talks about. It's what historians and sociologists and political scientists have been talking endlessly about for a very long time. And I chose to kind of ignore that genealogy, only because it seemed to me that debates about legal conceptions of sovereignty had really been slighted in the service of thinking about the Benedict Anderson onwards. So the scholars that I'm looking at, and here's where the Central European context does matter, really the language is sanitized, so they're not talking about the rights of certain nations to certain places, although they are talking in some cases about territory as an ethical value, right? And this is the idea of domicile. If you are in a place, if you're situated somewhere, you should have certain rights to be there.
And also
Yeah.
power that talks about self-determination, which is not territorial.
Yeah, so that's the invert, right? That's the exact opposite of that. It's by virtue of your personal jurisdiction, where you belong personally, that matters in the context of the empire, as opposed to the physical space in which you belong. And the Renner-Bauer argument doesn't seem to matter as much after World War I for people who are talking about what to do with the stateless. Some of them are arguing for this supremacy of international law, and others are talking about territory in this very normative way. If you just physically occupy a place, you should belong there.
David.
Right, so I'll do without this microphone. Thank you. So if one stripped all of the nuance out of your paper, all of the nuance, and it's a wonderfully nuanced paper, then I wondered whether it doesn't pose a rather fundamental challenge to Eyal's project. And so what you show is quite a radical shift from the interwar discourse to the post-war discourse. And a lot has to do, I think, with trust in the state. So do we want to think of the state as a kind of strong state where, which has a monopoly on violence, etc., because that's what will protect us as individuals? So then we can think of the state as the sovereign as a kind of trustee for humanity. But if we don't trust the state, then we want to kind of downgrade the state, go for some kind of pluralism, because that's where we think we'll locate our humanity. So it will shift from period to period. And so one can't make any, I don't know how grand you want to make your claims, but one can't make any grand claims about sovereignty as a trustee for humanity, because our intuitions about this will shift according to the circumstances.
I mean, the standard historian answer. I mean, it's good to be cautious and to recognize that discourses become, these arguments become...
Put all the nuance back in.
No, they become available at certain times. I mean, that doesn't mean that people after World War I didn't genuinely believe that this sort of singular sovereign state was the problem. I think some of them did. Not everyone did. And I think trust is a really important issue because, of course, some states during World War II appeared to be kind of good, and some states appeared to be kind of bad. And so the terms of the debate change. But whether my sort of historical perspective throws a wrench in the normative project, I don't think so. I don't think it does, because there's a bit of there's always a division of labor between trying to historicize and understand the context and the origins of where we come from, and then the ability to kind of make a normative statement. I'm not as good as everyone here as sort of making that normative step. We've talked about this. That's not really my training. But the implication doesn't have to be that there's nothing to learn from the post-war period, or that the claims we're making today about the sort of ethical dimensions of sovereignty are necessarily kind of contingent and false.
Can I ask a question myself? It was fascinating to me, your paper, and I wanted to press you as a historian on the post World War II. Because on the one hand, I agree with you thinking about, for example, the Nuremberg trial, there is a historian here in Israel, Laura Yokush, who wrote about the attempt of Jews to be represented in the Nuremberg trial as a group among other states, and this was rejected because they are not a state. So this confirms your thesis about the rise of the state and thinking through the state. On the other hand, a lot of historical research has been done about the uniqueness of Jews as stateless after World War II. So, for example, one thing that happened there was about the struggle about restitution of their property or of cultural property. So the argument was that the international law only recognizes states, but this means that the property of Jews would be returned to Austria, to Germany, and so forth, to those who took it. So there was a development in which the international law began to recognize Jews as stateless Jews, as represented by Jewish organizations as a collectivity, as opposed to either state or individual. So I just want to press you on this moment in which I agree that the trend is to return to the state, but I think there is a lot of imagination going on, legal imagination going on, precisely because of struggling with the problem of the Jews and the disconnect between the state and the group. So I just wanted to hear you.
Yeah, no, thank you. So, I mean, I think I can answer it by being kind of nuanced and not, and I think that's right. I mean, it doesn't, I hope my argument isn't, I mean, it's not, I'm not trying to say that there was no imaginary around the idea of kind of collectivities and individuals outside of states having legal standing and rights, but that it must tell us something that the people who hoped the most for this concept of international legal personality and thought of themselves as certain, scientists of the law, were resigned to the idea that that perspective could succeed, and that in itself is revealing, and it does link up to the way in which international institutions can support sovereignty and kind of work harmoniously together to kind of strengthen an international order that's fundamentally based on the idea of independent, equal states. And so having other institutions with some authority doesn't necessarily, undermine that perspective. It kind of goes to Tali's point about, who benefits from international organizations and international institutions defining refugees in a certain way. And actually, I think there's a really fascinating, very political, very politicized story about defining the stateless, defining refugees, separating the two concepts when it became necessary and useful. I mean, so you certainly can't think of international organizations as non-realist actors. They function as kind of in a power context as well and often facilitate it. But I totally take your point that there were a lot of interesting things happening, and the question of whether the Jewish case is unique might still support the idea that, the idea of the UN Charter of sovereign equality was what was really at stake, or what was thought to be important, at least rhetorically, and that, an organization authorized to go collect property in occupied Europe didn't necessarily contradict that fundamental view.
I actually have I want to throw a hypothesis. It's as a question, but it's a question that challenges something that you implicitly said about the difference or the tension between the league as an institution and these free-floating lawyers, and trying to suggest that we actually can see both as compatible with this kind of dreamlike, visionary, cosmopolitan view, because in some ways the league, even if we conceive it as an interstate organizations, even though it has a lot to do with empire and self-determination in its rigid sense, nonetheless was a more idealistic, utopian-like institution then perhaps, of course, the UN in some ways afterwards. And so I think some of the visionary undertone and the idealistic utopia elements were actually embedded in the institution itself. So just as a hypothesis, I would be slightly more hesitant to throw such a huge distinction, or not huge, just a clear distinction between these guys and the League. And actually, there was something in the way it operated, the infancy of the infrastructure of the institution, etc., that allowed such free-floating individual agency to operate. So it wasn't a full-fledged bureaucracy at least not at the beginning. So I think, in some ways, there's something in the institution itself that kind of allows these ideas to flower.
Thank you. So in a way, I think that's absolutely right, in that the League authorized these visions. I mean, its presence, it's just the discussions around the mandates, around these sort of high commissions and courts and Silesia. I mean, the idea that there was the development of institutions that could support these kind of internationalist, solidarist visions was absolutely true. But it might be possible that the bureaucrats and the lawyers who worked at the League operated under a different kind of utopian imaginary, let's say, from the lawyers who are writing about statelessness. And, it might relate to what happens when you actually try to implement things. So, empirically, the League of Nations sort of secretariat, lawyers, talk about statelessness, but they talk about how they can get rid of it as a sort of publicity problem. They don't want to bring it to the... that doesn't mean that they weren't idealist about their role as members and as experts in this institution. That's utopian too. And I do think it sort of authorized these other visions, but I think they were operating in the interwar period in a very different way and in a different context from academics, either with university affiliations or even more sort of free-floating associations.
Okay, I think we're finished. Thank you very much.
Thank you.